sir. Ms. Stoughton, is that correct?
Yes.
Thank you. The Honorable, the judges of the United States Court of Appeals for the Fourth Circuit. Oyez, 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 all persons having any manner of form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit, are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Please be seated. Well, good morning and welcome to the Fourth Circuit. In our first case, a couple of items to take up preliminarily. If there are to be any references to the jurors, you should use the numbers. You are not to use their names or any other identifying factor that would say who they are. And we have a cross appeal. So Mr. Wilkins will go first, followed by Ms. Stoughton, sorry. And then Ms. Limehouse will give the opening for the cross appeal, and we'll come back to Mr. Neiman, and Ms. Limehouse will be last. So hopefully we'll all remember that. Mr. Wilkins, we're glad to hear you in United States versus Lafitte.
Thank you, Your Honor. May it please the court, I'm Billy Wilkins, and my colleague John Nyman, and I represent Russell Lafitte. After 9 days of testimony, the jury began deliberating on the day before the courthouse was scheduled to be closed for 3 days for Thanksgiving. The jury deliberated all day and into the evening without reaching a verdict. Sometime around 8:30 that evening, the district judge in private swapped out 2 jurors. This new panel of jurors retired and in lightning speed reached a verdict of guilt.
In private, but with the consent of the parties that he questioned those jurors, correct?
Yes,
Appellant consented to the questioning of the jurors.
that's correct.
Okay.
And consented to the court questioning them in private without them being present.
Yes, sir, he did. I'd like to spend my time this morning addressing these critical and extraordinary jury dismissals, including what was said and just as importantly, what was not said just before and just after these 2 jurors were told to go home. Now, shortly after 8 o'clock, the judge began to partially read from 4 notes sent by the jurors. The notes were not shown to Lafitte or to his attorneys, nor was the identity of the jurors who signed those notes disclosed.
Was there any objection to not showing the notes to the lawyers?
No, the judge said he'd fully disclosed all of his notes.
But did any of the lawyers say, with respect, Your Honor, I'd like to see the note?
No, they did not.
I thought the district court judge at one point said that he didn't know who the numbered jurors were.
He said that. But of course, their numbers were on the notes, and the jury numbers were on the notes. He did say, I fully disclosed my notes, and no, I don't know who these jurors are. To answer your questions and remarks, Judge, I question whether the lawyer can be faulted. When the judge says, I've disclosed everything, well, Judge, I'm not sure. Let me see those notes to make sure you have disclosed everything. But in any event, the judge did not disclose that on the second note, the word pressured in the sentence, I'm being pressured to change my vote, had been underlined twice, nor did he disclose the last sentence in the fourth note. In reading these notes, the judge commented that my instinct is that we have alternates and we should get a verdict.
So are you taking the two jurors in tandem, or are you going to differentiate between them?
I'll differentiate, Your Honor. They stand alone. Each is separate.
right.
Each is a separate violation of the Constitution. And a violation of either one compels, in my opinion, a new trial.
Well, why don't we start down that road of taking one and then the other? Because it seems
All
like
right,
to
sir.
me there are different aspects that apply to the different jurors.
All right, sir. I'll do that. Referring to whom we now know is Juror 88, the author of the fourth note. Without
And just so
explanation,
I think I'm 99% sure, but this is the anxiety. Well, I guess in my head, there's the medication juror and the anxiety juror. This is the anxiety juror we're talking about?
that's correct.
Okay, I just want to make sure I know what juror we're talking about.
The word
93
anxiety was used just because that's how the parties began to identify them in the
Sure.
colloquy with
Right.
the court.
And 93 is the needs medication.
Yes, sir.
So now we're on 88,
88.
anxiety.
The judge said, first of all, without explanation, it would be a huge mistake to bring this juror, 88, into the courtroom. He then stated, maybe it's the best way for me to do is to speak to the jurors and create a record. And then he said it twice. And the third time he said, do I have your consent for me creating a record to question the jurors? And both parties said, we consent. And the government says, yes, we consent if the questioning, that is if it's, meaning the questioning, is on the record. As he was leaving the courtroom, the judge says, I'm going to take action. Everybody happy with that? Well, Juror 88, as well as 93, but I'm concentrating on 88 now, were already on the street when the judge entered the courtroom and said, I've dismissed these jurors. Lafitte's attorney immediately said, I object to the dismissal of this juror, Juror 88. He said, I thought we were just going to interview them. And co-counsel then said to the judge, Mr. Daniels' objection is akin to moving for a mistrial. And the judge responded, it's not a hung jury, I have alternates. Well, just because a judge or court or any court has alternates does not mean that a properly impaneled jury cannot become a hung jury. Indeed, I submit to the court that every defendant in every case, under circumstances like this case, is entitled to a hung jury if the panel cannot reach a unanimous verdict.
So can I ask you?
Go ahead.
Can I ask you what strikes me as the hardest question in this case for me? So let's just pause it on Juror 88. I don't think you have any plausible argument, and I don't hear you making it. I don't think you have any plausible argument that the district court did anything wrong by talking to Juror 88 ex parte, because the parties all expressly consented to that happening. And then the government said it needs to be on the record. It is. I'm literally looking at the transcript of the district court's conversation with Juror 88. So I get that. And then at the end of this colloquy, the court asks Juror 88, do you feel you can perform, or do you want me to replace you with an alternate? Sorry, that's not the important part. The court says, This is at SJA 3311. The issue is, are you able to perform your duties as a juror? Juror 88, at this point, no. I guess my real difficult question is, what is the district court supposed to do at that point? Because if a juror says they can't perform their duties as a juror, I don't understand how he can't dismiss that juror at that point. You can't let someone be on a jury who's told you they can't perform their duties as a juror. What is he supposed to do when she says that?
Well, I'll say what he's supposed to do, Your Honor. First of all, he asked the jury, do you want me to replace you?
No, I'm asking in response, when a juror says in response to, can you perform your duties as the juror says no, do you think there's any world in which the district court doesn't have to replace that juror? How would it not be reversible error to not reverse a juror who says they can't perform their duties?
He should do that what every circuit in this country that has addressed this issue says you should do. That's the D.C. Circuit, the 2nd, the 3rd, the 6th, the 9th, and the 11th. All have held that a district court may not dismiss a jury during deliberations if there is a reasonable possibility that the request to be dismissed stems from that juror's feelings about the sufficiency of the government's case.
So I assume your answer to that goes to the 2 questions or 3 questions before the ones Judge Heitens asked, where the juror says, I started to feel anxious due to some of the reactions to my decision. I don't want to be replaced. I'm usually very strong, but I don't want to be trialed for my decision. So is it your argument at that point the district court judge should have cut it off?
At that point, the judge should have said several things he could have done, but he had an obligation to explain to that juror that you have a duty to serve, and I, as the trial judge, have a duty to see that you continue to serve, and I have an obligation to do whatever's necessary to relieve whatever's happening in that jury room that's making you feel like, because of your decisions, you're being put on trial yourself. And he had a number of things he could have done. One, he could have brought the lawyers into the interview room so they could see what was happening, observe the judge questioning the jury, and make suggestions to the court as to what the proper course of action would be, including reminding the court that a juror may not be dismissed if her decision, her feelings stem from her decisions about the adequacy of the government's case. Or what he could have done,
If I remember correctly, when the district judge came back in, and he announced his decision, the counsel for Mr. Lafitte made his objection, the district court judge said something to the effect of, what else was I supposed to do? She was shaking so badly, she could hardly answer me. It just looks like a horrible dilemma for the district court judge, and now here we are way after the fact looking at it on a transcript and not with what the judge was actually faced.
The judge did come back and he said, I didn't think I had a choice but to dismiss her. But his choice was to send the jury back to the room, the one choice, with proper instructions to the jury about how they had to behave toward one another.
Okay, but again, once the juror said, I can't perform my duties, if the juror had stayed on the jury and the jury had convicted, the defense would have had an extremely strong Sixth Amendment objection to letting a person stay on the jury who said they can't perform their duty. I just don't think he had any choice but to. Now, maybe what he needed to do is declare a mistrial at that point. But I guess I'll just say it does not strike me as plausible that he had to, much less even could, have left a juror on the jury once the juror said, I can't perform my duties.
The judge said to the jury, well, it's your call. It's your call. You can either stay on this jury and you're on your own and you do what you best you can back in the jury room with those other jurors, or you can just leave the courthouse and go home. That's not a choice a juror can be given.
But that's before he said what I think is the most important question, the one that I understand, do not want to talk about, is the part where he said, at this point, are you capable of performing your duties? And the person says no.
As the 11th Circuit said in the Abel case, Judge, it's a tough legal standard that must be strictly enforced to protect the basic rights of every defendant. Otherwise, a unanimous verdict, the right to one, becomes merely an illusion. This judge could have suspended for the evening. Ask her, if we suspend for the evening, come back tomorrow, I'll charge the jury they've got to behave and be cordial and treat you with dignity. Just like this court has said in the Sawyer case, every juror has a right to speak without being coerced. That's what the judge should have done. He has to do everything he can to keep this juror on the panel. Otherwise, there's no such thing as a unanimous verdict as the Constitution describes it. What's going on, the transcript clearly shows that the focus of this entire hearing, interview with the juror, was what's going on in the jury room. Although the judge said, I didn't get in with her about what's going on in the jury room. The entire focus was what was going on in the jury room, and she was complaining about, she was being butted up, being in your face. She was being tried for her decisions. And that's where her anxiety came from, directly from her decisions.
Hold on, Mr. Wilkins. The district court also said at the very beginning, don't tell me anything about the deliberations themselves.
That's right. He did say that. And that's why she was hesitant to get into all the things. But she did say enough for us to know that she was being tried by the other jurors, some of the other jurors, for her decision. As clear as a bell. And that's why she said, I can't go on. Given the choice, I'll be replaced. But she doesn't have that choice. The judge has to do everything he can under these circumstances to make sure that there's a pleasant environment in that jury room where it's
a pleasant
like
environment? A trial judge has to make sure the jury room is a pleasant, that strikes me as a bit of an overstatement.
I'm sorry, Your Honor.
It strikes me as a bit of an overstatement to say that jury rooms have to be pleasant environments.
Well, I agree with you. That was an overstatement. You don't have to have a coercive attitude by some of the jurors in that jury room and some of the things that went on. But nevertheless, a judge can correct that. That's what trial judges do. They correct situations in the jury room so that the minority can be heard by the majority and their views respected as well. Now,
Before your time gets away, I would like for you to tell us a little bit about number 93, particularly as to why any objection to 93 was not waived.
Two things, Your Honor, about that. The judge says it's not practical to get her medicine and drive back. That's what he told the lawyers in the courtroom. That was an assumption the judge made because there's nothing in the record that shows that she would have to drive back. Indeed, the record shows, the affidavit, that she was outside the jury room talking to the deputy, going to get her telephone, a cell phone to call a friend. Her medicine was just a phone call away, but yet she was dismissed. And whether or not the judge, the defense attorney said, I agreed with that at that time. He did say those words, but that was based on the assumption that she's going to have to leave the courthouse, drive to her house, retrieve her medicine, drive back to the courthouse. All the time, jury deliberations would have been suspended. That's not the case here. But that's what the judge, that's what the defense attorney was laboring under. Now,
So is it your view that was an uninformed waiver? And
absolutely.
That's the defect?
If he said it, he did say that, but he said at that time. And the government says he said he agreed to this before the judge left the jury room. Now, if you look in the record,
Well, I mean,
anywhere.
after they came back, he said, we have no objection to your dismissing the juror with the medical needs.
we agreed to that at that time, meaning the time before.
Right.
But there's nothing in the record, there's no page or paragraph or sentence cited by the government where any language is there that he agreed. The lawyer was simply confused or just mistaken. But in any event, it was not an informed, intelligent, and voluntary consent.
All right. Thank you very much. Your colleague has some rebuttal time. Ms. Stoughton? Stoughton? Stoughton. Well, we'll get it right eventually.
May it please the court, I'm Katie Stoughton on behalf of the United States. With me at counsel's table is Emily Limehouse. I plan to address this morning the issues related to the replacement of jurors 88 and 93, including their affidavits, if the court has questions about those. Ms. Limehouse will address all the remaining issues. So the sufficiency of the evidence, the evidentiary rulings, and of course our cross appeal on the restitution issue. We've suggested a time split, but are happy to defer to the court's discretion, whatever works in terms of answering your questions. Turning first to Juror 88, we believe the district court correctly determined that Mr. Lafitte waived any challenge to his finding that the juror needed to be excused.
How?
Well,
So no, I'm just going to say that strikes, I guess I'll just say, it strikes me that you're right on the medication and wrong on this. I agree 100% that he waived his right to be present when they talk, and I understand your friend on the other side to agree that. Where do they possibly agree to the judge excusing Juror 88? I mean, you place a lot of emphasis, pretty much exclusive emphasis, on a remark the district court sort of makes as, I mean, I'm just envisioning this scene, and I guess I'm just envisioning that the district court is, if he's not literally standing up, he is starting to stand up and say, I'm going to do this and I'm going to take action, and he walks out of the courtroom and no one stands up and says, Judge, what does that mean? Or something like that. But like, other than this, I will say, to me, at minimum, fatally ambiguous statement about taking action and whatever the heck that means, I don't understand how they waive the argument. Specifically, we agreed to let you go talk to this juror as long as you made a record at the government's request. But we understood that what was going to happen is after you talked to her, we were going to come back in this room and have a conversation, not you come back and announce that you've dismissed her. Where do they waive that argument?
So I think it's important to look at the whole context of the conversation we're having. This discussion about Juror 88 was prompted by her sending a letter to the judge that said, can you please call an alternate? I'm experiencing anxiety and I'm unable to clearly make my decision. So our whole discussion about 88 is whether she's a viable juror at all.
Right, and we're going to get information because the judge says very appropriately, I give the district court a lot of credit, saying like, I'm not just dismissing someone because they're anxious, I'm not just dismissing someone, I think the judge even says during this colloquy, like, I'm not dismissing someone because they're potentially a holdout or disagreeing with people about the evidence, so I'm going to talk to this juror, which seems totally right to me. But that isn't, I'm going to talk to her and then make a decision without talking to any of you before I make my decision, right? I don't see anywhere the court says that's what I'm going to do.
I understand, Your Honor, and there is no express statement in the record from Lafitte's counsel. We agree with him on that.
I mean, there is, whereas to me, it's much clearer. I think you have a much stronger argument that the whole context of the conversation suggests I may well dismiss medication when I'm the person I'm calling medication. There definitely is a whole bunch of people saying, well, if they need their medication, they got to go. Like, I think your argument that the whole context suggests that the judge might do what the judge did with that juror is fair. I just don't see that for 88.
I understand, Your Honor. I think a lot of this is colored by our perception and certainly the court's perception, having been in the courtroom in the moment as we're navigating and trying to figure this out.
Right. Well, why don't we, just to save some time, why don't we just agree for purposes of discussion that as to 88, the court would find there is no waiver or no agreement before the judge left the bench to whatever it was he was going to decide. So now we're going to focus on what's the constitutional impairment when the judge has the in-camera interview and makes the dismissal.
Sure. So we don't need the waiver to win on any of the three arguments with respect to Juror 88. And I'll start with the Sixth Amendment argument, since that's where Mr. Wilkins focused his time. And this argument really applies to both jurors, but there is no Sixth Amendment violation in replacing Juror 88 or 93 because there's no causal link between her dismissal or her request to be dismissed and her views of the evidence. So we have no quarrel with the Brown line of cases.
That would be a clear case if we started with what Judge Hytens read initially and didn't look at the prior page, because there are two indications that there could be a causal connection. And that's, I think, the dilemma in this case is it's simply not clear-cut. So how do you address the two sentences? I started to feel very anxious due to some of the reactions to my decision, and I'm usually strong when someone is butting up what I don't want to be trialed. So how do we reconcile that with what happens on the next page?
So the district court's finding was that the juror was in what the district court called an emotional meltdown situation. So this is not simply a juror who's expressing that they're feeling uncomfortable in deliberations because they disagree with other jurors. He says she's visibly anxious. She needed a minute to compose herself at the beginning of that interview. This transcript, if you read it through, takes about 45 seconds, but the record says it was a 3-minute long interview. He says it was obvious she was under considerable stress. She was in obvious distress and advised the court she was not capable of performing her duties
And
as a
I
juror.
don't doubt at all that that was the perception of the district court judge. But if you're defense counsel, you've never been privy to any of that.
Understood, but that's by their own consent. They agreed that the best course of action.
No, they agreed to not be present for the questioning. They didn't agree to not have input on what the district court judge should do in response to these statements.
Right, they agreed to not be present, which put the district court in the position where he was the only person who had evaluated the juror's demeanor and was able to say, she is clearly incapable of continuing. She is visibly shaking. She can hardly speak. She's in this emotional meltdown situation. She's anxious.
But didn't she become get in that emotional meltdown situation because of the way the other jurors were treating her, arguably because of her view of the evidence?
It's possible, Your Honor, and I would point
Well,
the
if
court to...
that's possible, then why is there not a problem
I
here?
point the court to 3 different cases that we've cited in our brief where the court says it is possible that some sort of stress or something happening during jury deliberations can lead to an anxiety or some sort of medical issue. But if that medical issue is in and of itself severe enough that the juror cannot continue to deliberate, they can be excused without any Sixth Amendment implications. I'd point to the Huntress case in the Fifth Circuit. There were several notes that there were problems with the juror, that he didn't want to participate in the verdict, that he had a problem with the facts and the law of the case. He checked into a hospital during a break in deliberations overnight, and the doctor told the court his condition was brought on by the stress of jury service. But the Fifth Circuit said, we're not going to speculate that that breakdown was just based on the fact that he was a holdout, and there was no abuse of discretion in releasing him based on his physical impairment, his inability to continue deliberating.
Why doesn't this feel a lot like Brown to me? This feels very similar to the D.C. Circuit's decision in Brown to me, and I think it's similar in the sense of some of what the juror is saying sounds like just a general problem, but some of it starts to sound adjacent to the problem stems from what I think is the right answer and how people might react to what I think is the right answer. And what the D.C. Circuit says in that situation, you have to err on the side of assuming that it might relate to their view of the evidence, that the tie goes to the Sixth Amendment, the tie goes to the right to the impartial jury, and that if you don't, and I guess this goes back to, and it seems like at minimum, we should have all got back in the courtroom and that we shouldn't be having this conversation for the first time on appeal, that the district court judge should have had this conversation with the lawyers before just sending her home. I get it was late. I get it was 2 days before Thanksgiving and the district judge wanted to get everybody out of there. But it feels like this conversation should not be happening between counsel and the bench for the first time on appeal.
Well, can I add to that?
Sure.
Because it's all intertwined. It circles back to the Fifth Amendment question on the right to be present. And clearly, counsel Mr. Lafitte and counsel were present when they had the discussion about the judge interviewing the juror. But it's highly debatable that they were present when the decision was made to dismiss the juror. So it seems like there's a pretty strong Fifth and Sixth Amendment connection here we have to resolve.
So if I could address Judge Hyten's question on Brown, and then I'll go to the Fifth Amendment issue. I would point to the D.C. Circuit's decision in McGill, which of course followed Brown, where they said even if a known holdout juror requests dismissal because they're having a heart attack, Warren Brown doesn't prevent that dismissal. So you can be so anxious and so stressed because you're the known holdout juror.
Your heart's at 150 or right.
Right, but if you're having a heart attack, no reasonable court is going to say, I'm sorry, you've got to come back and continue deliberations. If you go into premature labor because you're stressed because you're the only holdout juror, the court's going to excuse you. And what the court is saying here is she was incapable of functioning. She told me twice before I interviewed her and during the interview that she could not clearly make a decision. She couldn't uphold her duties as a juror. That was the district court's perception, certainly, which it has reiterated several times.
Where did she say that in this transcript? That I can't make a decision?
She said, her note said, I'm unable to clearly make a decision.
The note, okay, but not during the interview.
Yes, the interview, she said she cannot continue to perform her duties as a juror. So I think the McGill case says, it may be caused by stress, but at some point there's an independent medical need that's legitimate enough that the juror's got to be excused. And the district court didn't clearly err in finding that that's the status that this juror was at. Turning to Judge Agee's question on the Fifth Amendment issue, I presume if the court finds that Mr. Lafitte did not consent to not being present, it's going to find he was not there and neither were his counsels. And the moment that the judge made the decision to excuse the juror.
And Runyon says that's a Fifth Amendment violation.
Yes, that's right, Your Honor. So We have argued this under plain error review, so Mr. Lafitte would have to show an effect on his substantial rights. But even under a harmlessness beyond a reasonable doubt standard for the government, we think we would win under either.
Really?
In terms of
Could
no
you try,
effect-
I mean, I will describe myself as politely skeptical of your harmless error argument, but I invite you to try to convince me that I shouldn't be.
Sure. So we think the error is harmless beyond a reasonable doubt because here the court came back and said, I've excused juror 88. She's in this emotional meltdown. Defense counsel objected, and the court said at JA 2286, had I come back and told you she was emotionally incapable of functioning and that she asked me again to remove her, you would have objected to that? Defense counsel said, I think we would have said that it's a hung jury. And the court said, it's not a hung jury, I have alternates, which is an accurate statement of the law. under
Okay, so for
20%.
purposes of analyzing the harmlessness of the possible Fifth Amendment violation, I guess, right, what we have to hypothesize is that the district court did what it was supposed to do, which is come back in the courtroom and
Right.
say, I'm going to dismiss her based on what I just heard, and that lawyers make the arguments, and the court says, yeah, but I'm still going to dismiss her.
Right,
And
and
you
the-
said that would be harmless because if he'd done that, that clearly would not have been reversible error, in your view.
Yes.
Okay.
The harmlessness on the Sixth Amendment is a different question that I'm happy to address. But even in terms of the Runyon analysis of whether there's an effect on the substantial rights from a Fifth Amendment violation, the alternate was selected along with the other jurors and the alternates during voir dire, where the defendant and his counsel were present. They sat through the same opening and closing charges. They sat in the jury box for all of the trial. They affirmed the verdict when they were polled after the verdict was returned. So we think under Runyon,
But that's going to be literally true in any case that ever comes to us on appeal, because if the jury hangs or acquits, there's no appeal. So the only situation in which something like this would ever come up on appeal is basically this situation.
it could. I mean, I think where you might
No,
have-
literally, can you think of another way this could possibly come up before us on appeal? Because if a jury acquits, there's no appeal.
That's right, Your Honor. I think where you might have an effect on substantial rights is a case where perhaps the replaced juror was substituted with an alternate who maybe hadn't been sequestered, or where there was some sort of evidence that that juror had been tainted in some way. But here you have jurors that sat through everything the jury did. They were sequestered, they were put in a room, they were instructed not to speak to anyone. And so I think under Runyon, it's clear that there is no issue with having substituted either juror with jurors who had been sequestered and who had sat through the trial just because Mr. Lafitte and his counsel weren't present at the
Of course,
time that the
that
district court made the decision.
presumes there was no error in removing the juror to start with.
That's right, Your Honor.
So how would you do the harmlessness under the Sixth Amendment? Assume, for purposes of this question only, that we were to conclude there was a Sixth Amendment violation. How would you do the harmlessness then?
So I think that a Sixth Amendment error can be harmless or have no effect on substantial rights if there's an independent, legitimate basis for excusing the juror. And so in the McGill case that I discussed earlier, the district court, I'm sorry, may I answer the question, Your Honor?
Go right ahead, please.
The district court said, I'm removing the juror for a juror misconduct issue or a failure to follow instructions. And independently, I'm removing the juror because he's removed his jury notes from the jury room, which he shouldn't have done. So on appeal, the defendant says, this juror, there were notes, like it was pretty clear this was the holdout juror. There's a Sixth Amendment issue here under Brown. And the D.C. Circuit said, we don't even have to address the Sixth Amendment because the dismissal stands on that independent basis. So I think if the court were to find there was an independent, legitimate basis supported by Rule 24, that you don't even have to address the Sixth Amendment issue, even if there's an error. However, I will acknowledge the Second, Ninth, 11th, and D.C. Circuits have all just summarily remanded where they found a Sixth Amendment error without doing any harmlessness inquiry. I'm happy to answer any questions. I haven't addressed Juror 93 yet.
All right, thank you very much.
you.
Ms. Limehouse, if you'll give us your part, including whatever you want to say about the cross appeal.
May it please the court, I had intended to address the arguments related to potential bias and motive evidence, then the sufficiency of the evidence arguments with respect to counts 2 and 3, and then our cross appeal unless the court would have me address matters in a different order.
Okay?
With respect to the arguments related to what the defense counsel argues as evidence of bias or motive, the district court did not abuse its discretion by excluding evidence that was not probative of bias or motive and would have resulted in confusion of the
This is
jury.
the bank board members.
That's correct.
question, okay.
This is direct testimony of the defendant's witnesses during direct examination and the Charlie Lafitte memo is what I'll call it. So related to both, I think it's important to kind of frame how these issues related to the sale of the bank were presented during the entire case. During the government's case in chief, we called 5 board members. The defense asked 3 of those board members about the potential sale of the bank, and the government objected based on relevancy. the court allowed that line of questioning as proper cross-examination under 608, allowed the defense to impeach the government's witnesses related to issues surrounding the sale of the bank. The evidence was not excluded. In support of their appeal here, the defense cites a portion of Charles Lafitte III's testimony. That testimony was actually related to the shareholder repurchase program and not the sale of the bank. The court excluded the testimony about the shareholder repurchase program as an improper attempt to impeach a government witness using extrinsic evidence in violation of 608B. The issue came up again during Charlie Lafitte's testimony. This was a question about a, quote, riff in the board. The court excluded that testimony as another improper attempt to impeach the government's witnesses with extrinsic evidence. The question was later brought about this 2020 board retreat, and the court asked defense counsel if it was the same issue. After defense counsel said that it was, the court again held that it was improper impeachment under 608B. The words motive and bias, the argument about motive and bias was not presented to the court until the testimony of Gray Henderson. It was actually during a break in the testimony the court stopped, and that's at JA 1674, and said he wanted to make sure he fully understood what counsel's arguments were and give them an opportunity to explain why this evidence was admissible. At that point, the court's defense counsel argues that it's relevant to motive or bias, and the court's analysis shifts from whether it's proper impeachment under 608B to determining whether the evidence they sought to admit was probative of motive or bias. The court at that point gives defense counsel half a dozen opportunities to describe to the court why evidence about the potential sale of the bank through its own witnesses was probative of motive or bias. I'll point the court to JA 1677 through 1680. And on 6 different occasions, the court seeks to elicit from defense counsel an explanation of why this evidence is probative or motive or bias. Despite numerous opportunities to do so, defense counsel could not articulate how this evidence they sought to elicit established motive or bias. And that was a correct finding. There's no abuse of discretion in that finding. For the court to determine that the evidence they sought to elicit was probative of motive or bias, it would have had to establish that there was some board retreat in 2020 during which certain board members expressed a desire to sell the bank, that a year later when Murdoch and Lafitte's criminal conduct became known to the bank, they used that conduct as a pretext to fire Russell Lafitte from the bank's board, that a year later when he was being tried for that criminal conduct, the government called the same board members that wished to sell the bank, and that they had a motive and bias to testify falsely against Mr. Lafitte to advance their interest in selling the bank. As the court found, this is just too remote, too attenuated, and too speculative to be probative of motive or bias, and therefore should have been excluded under 401. But the court also made findings not only under 608B, but also and 401, but also under 403. The court found that if the court were to allow the defense to elicit this testimony from its own witnesses via extrinsic evidence, that it would create a trial within a trial. What the court called was a circus. And the district court has wide latitude to put bounds on motive and bias evidence. And so even if this court were to find that that evidence was relative to motive or bias, the court did not abuse its discretion in finding that it would have created confusion with the jury and a trial within a trial.
So your time is fleeting if
Yes,
you
Your
want
Honor.
to get to any of the other things.
I'm going to turn to the cross appeal, if I may. I'll address the sufficiency of the evidence arguments briefly, Your Honor, if I may save my rebuttal time to deal with the cross appeal, if Your Honor wishes. Just briefly.
Well, I think if you want to deal with the cross appeal in rebuttal, you better say something about it now.
Yes, Your Honor.
Otherwise, there's no way the other opposing side can respond to it.
Thank you, Your Honor. Yes, Your Honor. So the district court, we believe, plainly and reversibly erred by waiving interest on restitution without first making the requisite factual finding that Mr. Lafitte was unable to pay interest on restitution. Of course, 3612F requires the court to impose.
But the government made no objection.
That's right, and that was absolutely our error. We should have objected during the court's oral pronouncement.
And the government constantly argues we should deny relief to criminal defendants on claims that they're forfeited because forfeitures are really, 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 really tough. And this is a little bit in tension with what the government says in virtually every criminal case.
I understand, Your Honor, but our failure to object should not be held against the victims whose losses would not be made whole. They would be out about $190,000 a year.
Well, hold on. That presupposes the court couldn't have made the findings. Once the court makes the you're presupposing that the error is that the district court waived restitution. Maybe the error is the district court did not explain why it was waiving restitution. So the prejudice argument you just started to make presupposes the court could not have done this.
Sure, but it's based on everything that was presented to the court, both in the pre-sentence report and at sentencing. All of the discussions on the record about the defendant's financial condition do not support a finding that he was unable to pay interest on restitution. In fact, there was a discussion about the defendant's ability to pay forfeiture in addition to restitution. Defense counsel argued that Mr. Lafitte would not be able to pay both. The court acknowledged that it had adopted the findings in the PSR as findings of fact for purposes of sentencing. It highlighted the defendant's $10 million in assets and $5 million in liabilities, and that the restitution judgment was about $3.5 million. And the court doubted that there would be any issue in the defendant being able to pay both restitution and forfeiture. And so I think not only does the PSR not support a finding that he was unable to pay interest on restitution.
Right, but we're not making any findings on the appellate level in the
Correct.
first instance.
Correct. And while the government did not object and should have during the court's oral pronouncement, we think the court's failure to make a finding before sort of checking the box that interest was waived was a plain error and necessitates this court to.
Do you have any sense, it looks to me from trying to figure out how this happened, is that somehow the form the court used is like a screwed up, tweaked, modified version of an official form that omits a box?
Well, I will say this isn't in the record, but we did, of course, research whether this was the form that's typically used. This district court has used the same form in restitution judgments prior to this case and since this case.
So it's an irregular, modified version of an official form?
There is no checked box in this form.
But there is an official form that does have a checkbox.
That's correct. On the district court form does have a box for a finding, not just that interest was waived. But we argue that even if there was a checked finding box on this judgment, that would not be sufficient to satisfy what the statute requires, because there's absolutely no discussion on the record
All
of
right.
his financial condition.
Thank you very much.
Thank you, Your Honor.
Mr. Neiman, we'll be glad to hear from you.
Thank you, Judge Agee. The government's cross appeal is meritless, and Mr. Wilkins and I are content to rest on what we said in our briefs about it. We'd like to use the limited time we have in rebuttal to return to the more significant issues in this case, that is to say the dismissal of these two jurors. We haven't said much about juror number 93 today. Even if the government were right to say that plain error review applies as to 93, we think that that's a basis for a new trial, even under.
Well, no, the government doesn't say it's forfeited. They say it's straight up waived because of the, we agreed to it at, you know the part of the transcript, we agreed to it at the time, it's not a forfeiture. That's a straight up waiver.
Yeah, I understand the waiver issue, Judge Heitens. We've explained in our brief why we believe that's not an effective waiver. It's not knowing, it's after the fact. Nonetheless, I agree. If it's a waiver, we're out of
Can I ask you just one
line.
question about waiver? You suggest that it's a problem that there's no evidence Mr. Lafitte agreed to it. Do you have any authority for the proposition that this is the kind of waiver that can only be made by the client, that it's like akin to the right to testify, the right not to plead? Like almost nothing has to be made by the client, and it strikes me as implausible that this is something the client has to do.
Yeah, there is a Second Circuit dissent that I believe we've cited,
Sure.
but it's a dissent we acknowledge. We are extrapolating that rule from that line of precedent.
Okay.
We'd be asking the court to extend that line of precedent.
So why don't we move on to number 88?
Yes, Your Honor. 88 provides a much clearer path to resolving the case. The government has conceded that the Sixth Amendment claim as to 88 is preserved. The government hasn't had effective answers to the court's questions about its preservation argument as to the Fifth Amendment claim relating to 88. So the question then becomes, well, how do the claims relating to 88 get resolved by this court? Let me start with what Judge Heitens said was, in his mind, the most difficult question in the case. What was the trial judge supposed to do when, at the end of this interview, the juror 88 said that she was unable to serve in response to that question? At least two responses on that. The first comes from the Fifth Amendment, right? I mean, the Fifth Amendment right to be present is clear. So the absolute wrong response from the judge was to simply dismiss the juror at that point. Mr. Lafitte had a Fifth Amendment right to be present when the judge made his decision about whether to dismiss her. So the judge had an obligation under the Fifth Amendment at that time to go back into the courtroom, to have the court reporter read through the interview, and then to consider the arguments of counsel about whether number 88 should have been removed based on the full context of that interview. And I'd submit that there's a substantial possibility that if the court reporter had read back the entire interview of 88, the outcome would have been different. How do we know that? Because when the judge came back into the courtroom, he no doubt said these things like that 88 could hardly speak to him, 88 was shaking. He did not say to the parties that 88 had said all these things that are also in the record.
If he'd come back, that would solve the Fifth Amendment problem, I think, but not necessarily the Sixth Amendment problem.
I'm not sure I understand.
If the judge had come back into the courtroom
Yes.
before dismissing the juror and then had that discussion, dismissed her anyway, I'm saying that seems like it would solve the Fifth Amendment problem, but not the other.
That's correct. But my point is the Fifth Amendment problem alone was harmful error and cause for a new trial.
Well, not necessarily. I think what Judge Agee may be saying is not necessarily. So let's assume he comes into the courtroom. Look, as a descriptive matter based on what the trial judge says, let's just hypothesize that I'm pretty confident what would have happened is he would have walked into the courtroom and said, I'm going to dismiss her. And then the lawyers would have made arguments and he would have said no, based on what the trial judge says when he comes back. So which brings me to the question, the real question is whether that's a Sixth Amendment error. Because I think the government's got a pretty good harmlessness argument on the Fifth Amendment because based on my reading of the transcript, I don't feel particularly doubtful what the trial judge would have done had he come back into the courtroom before dismissing her.
Yeah, so I mean, I do think the Fifth Amendment problem is harmful error because the trial judge had not revealed to the parties and perhaps had not considered himself these other things that the juror was saying. But separately from that, the Sixth Amendment violation here was also harmful error that requires a reversal. The government's take is, well, that there were these things that the juror said that were independent reasons to reverse her, but that leads to the second thing that the judge should have done during the interview, which was to say when she said, I'm going
to give you an extra 2 minutes because we want to hear this.
When she said, I'm unable to serve, to ask himself why. And the answers are apparent in the transcript. She had said, I started feeling anxious due to some of the reactions to my decision. The government cited a D.C. Circuit decision that declined to find a Sixth Amendment violation when the connection between the reason for dismissal and the juror's view of the evidence was speculative. There's no speculation on this record. Juror 88 herself articulated the causal connection. She told the judge, I'm feeling this anxiety due to the reactions to my decision. That paired with the fact that she immediately then said, I don't want to be removed, but I'm usually very strong when being butted up against, but I don't want to be trialed for my decision. All of those data points confirm that the reason why the note was sent in the first place and the reason why ultimately Juror 88 said, I'm unable to perform is because of the experience that she had in the jury room.
Can I just ask you, so let's just hypothesize that the district court concludes the following. This juror is shaken, all the things that the district court said, this person is not capable of deliberating. I cannot let this person deliberate. But also, I can't conclude that the reason this person is incapable of deliberating is unconnected to their views of the evidence. Like, let's posit the district court thinks both of those things are true. I'm not sure. You seem to be resisting saying this. Your view then is they have to dismiss her and declare a mistrial, right? If the district court believes those two things are both true, is that what the district judge does? Dismisses the juror and declares a mistrial?
I think that's certainly one of the things the judge could have done.
What else could he do in that situation?
Well, the extraordinary facts of this case suggest that, among other things, here at 8:45 at night on the night before a holiday.
Take a night, let's calm down, let's...
Yes, absolutely. Provide instructions to the entire jury saying treat each other with respect. We're coming back tomorrow and we'll
see if things are better then.
Yes.
But you haven't claimed that's some sort of independent error. I mean, this is your claim goes to dismissal.
Yes, our point is that her dismissal was error. My response to Judge Heitens just suggests the judge did have a lot of discretion in terms of how he could deal with this issue. What he did not have discretion to do is simply outright dismiss her in these circumstances. Unless there are further questions, thank you.
Thank you very much. All right, Ms. Limehouse, you have rebuttal on the cross appeal, which I remind you is not sir rebuttal, but
Yes,
the
Your Honor.
judges, of course, can ask you about anything.
Yes, Your Honor. We just want to clarify one matter. The error we are claiming is not in waiving interest. It's in failing to make the requisite factual finding to support that waiver of interest. If the court has no further questions with respect to our cross appeal, we ask that the court vacate the restitution order and remand for the limited purpose of determining whether Mr. Lafitte had the ability to pay interest on restitution. Thank you.
I want to thank counsel for their excellent arguments in this case, and we're going to come down and greet counsel and then move on to our next one. All right, Mr. Cooper, we'll be glad to hear from you when you're ready.
May it please the court, I am Jeremy Cooper on behalf of Jay Fulse, the appellant in this case and the plaintiff below. I will begin with the threshold issue that the court asked us to address in supplemental briefing on the question of appellate jurisdiction and the finality of the judgment. The Britt case established a rule in which a dismissal without prejudice would be final in a situation in which no leave to amend was granted. And of course, the dismissal in this case involved no leave to amend. I think where you get into, whether this applies or not, the distinction here is that we weren't quite to the point in the litigation in which the amendment of the complaint was at issue. Here it was the correction of a alleged defective form.
So he could still have amended his complaint?
I believe that he could have amended the complaint. I don't disagree with that. That is one approach that he could have taken.
But he did not?
He did not. And having filed the appeal, under the literal language of the rule established in Britt, I believe that the appeal, the final order in this case was final. Appealable order was not interlocutory because there was no leave to amend granted. Now, again, leave to amend wasn't really at issue here. But you have the Dupuy case, which is not a precedential case, if I recall correctly, but the court found in that case that when there was leave to correct a defective form, that the order was not final and appealable in that case, and the court lacked jurisdiction. So, if you extend that sort of application of that rule to this case, I think that the solution is that the Britt rule encompasses the facts that are presented here, in which there was a dismissal without prejudice, without any type of leave to cure whatsoever. I know I quoted in the supplemental brief, there is a portion in Britt where the opinion discusses, the ability to cure deficiencies, not just to amend a complaint. So, I think that there's room within that rule for the court to find that this is a final appealable order. So, And I think really this dovetails with the question also, of what is appropriate for a district court to do when you have a defective form like we had in this case. Of course, I'm also arguing the alternative that it did comply with the rules, but we'll start with the.
So let's start with the rules. Your brief frames the question as whether the local rules authorize filing by fax. Sorry, whether the local rules forbid a pro se litigant from filing a complaint by fax. But isn't the relevant question whether the federal rules of civil procedure whether they authorize it. So the way I read the federal rules of civil procedure is it says pro se litigants can only file electronically if local rules give them permission to do so. The advisory committee notes at least say very clearly that faxing is a form of electronic filing. Therefore, the question is not whether the local rules forbid pro se litigants from filing by fax, it's whether they authorize them to file by fax. And I guess I don't see where these local rules affirmatively authorize pro se litigants to file by fax.
Well, Your Honor, I don't know if I have a response to that shows where they explicitly authorize filing by fax. I think that, they have the prohibition for filing a complaint by fax, which I'm arguing because it is in the rule that applies to the manner in which counsel are supposed to file.
Sure.
That it doesn't expressly forbid that. Now, there's a general rule concerning fax filing that permits it in a more general sense than the rule that was cited by the district court in dismissing the appeal. Now, as far as I think it's also relevant that the rules permit a judge to accept a filing that is delivered to the court, and I think that
But the court did accept the filing, right? We all agree.
It did.
We all agree that the court. What happened here is not the Allen versus Atlas box situation, where someone tries to file something and the clerk's like, "Nope, I won't take that." Right? We all agree that it's not that the court refused to file his complaint; it's that the court filed the complaint and then dismissed it. Right?
Yes, Your Honor. I think we all agree that they did accept the filing. It was filed. It was docketed. It's in the court file. It's in the appendix. I
So
think we all agree
the
on that.
question here is not was it timely filed for statute of limitations purposes? It's whether or not you can take cognizance of the fact that the document was filed in contravention of what appeared to be in contravention of the local rule.
Yes. So.
Well, here's if we were to rule for you, how would we do that without, in effect,
And if we affirm, if we disagree with you, he could go back and amend. So what's happening here? Why are we here?
Well, I think the reason that we're here, Your Honor, is that Mr. Foltz was a pro se litigant at that point and was in all likelihood operating under the misapprehension that the court's dismissal of his complaint would preclude him from presenting at least one of his claims in the complaint because of a statute of limitations issue. That is, I think, probably the most realistic explanation of why he filed the appeal rather than refiling the complaint. I think,
but if he refiled the complaint, even at this point, that would be when the statute of limitations question would arise, if at all.
Sure, because we're not here to decide that question in particular. I mean, that's not the issue that's encompassed with the.
And West Virginia does have a tolling statute, right?
Yes, Your Honor. So I think that there was some discussion by the respondent concerning, that there was additional time left to file on some claims. But I believe that the defamation claim is the one that has a 1-year statute of limitations that would have been implicated and that he was concerned about.
It was not cited in any of the briefs, but did you come across West Virginia Code 55-218? The general tolling would appear, let me rephrase, what appears to me to be the general tolling provision in West Virginia?
Your Honor, I know that at some point in the past I have looked at that, but I have not looked at it recently, and I could not.
I mean, it seems to me to say that for a period of 1 year, this is 52-2-18A, that says, for a period of 1 year from the date of an order dismissing an action or reversing a judgment, a party may refile if the initial pleading was timely filed. We all agree the initial pleading here was timely filed. And 1, the action was involuntarily dismissed for any reason not based on the merits. The basis of the dismissal here does not seem to have been based on the merits. Or the judgment was reversed on a ground that does not preclude a filing. So I guess prima facie, that looks to me like he had a year after the district court dismissed this action to refile.
Your Honor, I will be honest, I'm not expressly prepared to comment, but
Fair.
the way that you presented it sounds like a reasonable interpretation.
Well, I guess the
statutory
last step I
language.
left is that the Supreme Court has told us that federal courts apply state law tolling
Sure.
rules, so that the federal court would apply the state tolling rules.
Yes, Your Honor.
Fair.
So I think, I don't think that there's.
Can I ask you a different
disagreement.
question? Do you
Yes.
concede that filing by fax is a form of electronic filing?
Your
Because the
Honor, so-
advisory committee notes seem to say that pretty expressly.
Right, and I think that, there have been a number of different amendments of the Federal Rules of Civil Procedure, going back and looking at that. I believe that what you're referring to is accurate, that it has been construed as a form of electronic filing. I think that I don't have any choice but to concede that.
So what you mentioned, the defect of, one of the issues the parties join issue over is whether this is a defect of form or a defect of the method of filing, right? And candidly, I've read all the cases you cited, and I presume those are the cases we have. And I guess what I'll say candidly is those cases just, when I read them all, they all just sort of declare it's X or they declare it's Y, and none of them really explains why it's X or why it's Y. So could you just take a step back? Why should we think of, I guess my gut is that filing by fax versus in person, to me, my gut is that seems more like method than form, but why should we think of that as a form problem?
Okay, Your Honor, I have to, okay, so you're asking the distinction between a defect in the method versus the defect of the form.
Correct.
So,
And I think you want us to view it as a defect of form, and so the question is, why should I think of that as a defect of form?
well, I don't know, I mean, the cases that we cited, do they really, make a distinction between method and form? Am I missing something here? I mean, I think that you have the situations in which people.
Form would seem to be if they had a rule that you have to file on white paper and somebody filed on green paper, as opposed to the method of hand delivery, email, fax, courier.
Or you have this rule like the Second Circuit's where the docket number has to be in 2-inch size font.
Right. I mean, I think that the rule that's kind of embraced by those cases is that, if you file something the wrong way, whether, you send it by email when you're not supposed to, if you, don't pay the filing fee, some type of defect, technical defect that doesn't have to do with the actual, substantive aspect of the complaint, then, you nevertheless preserve the statute of limitations, and that it is actually deemed filed. I think in this situation, he did present the complaint. He did it in a way that, in all likelihood, violated that local rule, unless you accept my argument that it was, the impari materia argument. But it doesn't sound like the court is incredibly sympathetic to that argument.
Didn't he file a motion
Yes.
to file by fax? So that would indicate to me that he knew he was violating the local rule, because he filed a motion seeking to be able to file it by fax.
I don't think that that's an unreasonable inference, Your Honor, and, but of course, the rules also permit a judge to, I think, accept a document that's delivered to them, and I think, within that, he was asking the district judge to exercise discretion in that regard.
And it was accepted.
It was accepted.
right?
It was accepted, but then he was not allowed to proceed
Was
on
the
it.
motion ruled on or addressed in any other way, other than the fact that the it was actually accepted?
I think it was ruled on by the method of dismissal for.
The motion.
Yeah, I believe the motion to proceed by facts, I believe, was substantively ruled on by the dismissal. I mean, that's the only reason it was dismissed, is because he filed it in a way that the district court construed to be against the rules. It wasn't based on any kind of other, substantive reason or defect in the content. It was only based upon the form. So, you have on the one hand, they accepted it, they filed it, they made it part of the docket of the case, and then on the other hand, he wasn't able to proceed on it. He's neither the first nor the last pro se litigant.
Except he could proceed on it. He could have amended. I thought we agreed on that.
I do agree on that.
Okay.
He could have amended, he could have, well, not amended, but he could have refiled, I guess, by filing it in a manner that the district court construed to be within the rules, such as by mailing or hand delivery. And certainly, I would not endorse a method of filing that causes the merits of your case to hang on an esoteric appellate issue. I certainly appreciate the cutting footnotes in the respondents' briefs on that matter. I understand that. Nevertheless, he presented this claim, he delivered it to the court accepted it, and having accepted it, I think the argument is that it's improper to just simply dismiss it. If it wasn't that we're not arguing over whether he delivered it. He did deliver it.
What if the court, let me ask you this, what if the court had, instead of outright dismissing it, entered a show cause order that basically said, you filed a complaint by fax, you're not allowed to do that under the local rules, I order you to file by hand within 10 days or I'm dismissing. Do you think the court could have done that?
I think the court could have done that, and that would probably be, especially in light of the Britt decision, that would take away some of the ambiguity about the situation, especially for a pro se litigant. I cannot say that would have been an appropriate way for the court to handle it, because that would have given him an opportunity to cure. Now, I understand Britt doesn't require district courts to give an opportunity to cure. It just is a rule for interpreting finality. But if we're talking about, trying to give people guidance about how to appropriately proceed, it would be, I think, salutary for the court to, provide that type of ability to cure a defectively filed document, rather than to dismiss the case and then, leave it up to the
Pro se
subjective
litigant to figure
interpretation
out that he can refile because everything's told and everything's, like, to expect a pro se litigant to figure all that out.
Yes, Your Honor, essentially. My time is almost at an end here, so I will, reserve the remaining 5 minutes.
All right, thank you very much. Mr. Buck?
Thank you, Your Honor. May it please the court, my name is Thomas Buck. I represent the defendants Tiffany Hoffman, Christopher Cook, and Jonathan Stepetich in this case. At the heart of this case is a question as to whether litigants are to follow the rules and whether the judge has the right to enforce the rules. In this case, the appellant is not disfamiliar with procedural processes. He has filed numerous cases in the past, both in federal and state courts, and he has successfully paper filed as required under the federal rules. In this case, he elected to fax file, keenly aware it's not provided for in the rules at all. And you are correct. If it's not provided for in the rules, it can't be done. The only way it can be done is by local rule or an order of the court. The local rule did not provide for him to electronically file in any fashion, so he properly applied to the court for a court order. That was denied.
Except it was granted, right? I really wrap myself around the axle, like, except the court did file the complaint, right? So is your view the court shouldn't have filed the complaint?
No. What happened is the clerk does not have the discretion whether to accept a filing or not.
Right.
And there's many cases cited that support that concept.
Sure.
So the clerk did the right thing in this case. This document came in. It came in inappropriately. It came in violation of the rules. The clerk nonetheless docketed it. And that was good, and that was correct, and that was the right thing to do.
And that stopped the statute of limitations. We all agree once the clerk does that.
And there's many cases. In fact, most of the cases cited by plaintiff are statute of limitation cases, not cases applicable to this case. So arguably, that would stop the statute of limitations. The saving statute you pointed out in West Virginia 55-218, like call it the saving statute, gives them a year to fix it. So that's what it really comes down to in this case. Plaintiff simply needed to follow the rules and refile the complaint the right way, the way he has done
Sure.
many times in the past.
Can we agree, though, that maybe the district court could have handled this a little bit more delicately vis-a-vis a pro se litigant? Because it's a pretty nasty combination of circumstances that the district court sits on this motion for 2 weeks. 2 weeks, when the plaintiff is clearly worried about the statute of limitations. The district court takes 2 weeks to rule on this motion and then just denies it. When it seems obvious to me that the district, and I recognize it's easy with hindsight, but it seems obvious to me that what the district court could have easily done here is order to show cause why I shouldn't dismiss this already filed action. Please file in paper. Why wouldn't that have been, I'm not saying it was necessarily an abuse of discretion, but why would that have not been obviously the better course of action with the pro se litigant?
Well, I think the court giving him 2 weeks to fix it was kind of nice.
The court didn't give him 2 weeks to fix it. The court sat on this motion for 2 weeks and then dismissed his action and didn't say he could fix it.
Yeah, but in the matter of that 2 weeks, plaintiff could have easily just either mailed it, it would have got there by mail, and that would have cured the problem. Or the plaintiff, during that 2 weeks, could have taken paper copies to any court in the Northern District. Didn't even have to take to Wheeling. The rules provide specifically they can go to any court at all, and that's 501C. Go to any court, and the clerk would then forward it to the proper court. So the judge, the 2 week pause is pretty much giving him that opportunity.
How does he know that? As far as he knows.
Because he's a frequent flyer. He's filed a lot of cases. He
I
knows
guess
how
my
to do it.
interpretation would be the district court just took 2 weeks to rule on a motion, not the district court was giving him 2 weeks out of the kindness of its heart.
Well, either way, he had a 2 week window to fix it before the court even ruled on the motion for leave to file inappropriately. And then after, he still could have filed a motion to fix it. We could take a look, I mean, if you look at.
Well, not even a motion to fix it, right? If you're right about the saving statute, he could have literally just filed a new complaint.
He could have filed a new complaint without any problem. He could have filed a motion within this case if he wanted to, under the local rules, because it would relate back, non-pro-tonque. There's a specific provision in the local rules to allow it to happen. So plaintiff could have simply done that as well. That's.
But I suspect that under this rule, you think he can't do it now because, according to my law clerk, the district court's order was June 22nd, 2023, which is more than a year ago, right?
Yes.
So you think if we affirm here, you think he's now time barred?
Well, that would be the argument I would most likely make.
Fair.
If he does refile.
Right.
But
Fair enough.
Unfortunately, plaintiff hasn't done anything to put that issue before the court, so basically we'd be issuing an advisory opinion on that at this point. So, plaintiff's original argument was there was some discrepancy between the Federal Rule of Civil Procedure 5 and the local rule corresponding 5.01 at sequence. There is no problem here. What we simply have is a plaintiff who didn't follow the rules, and even after being pointed out, hey, no, you can't do it this way, never did anything to fix it. And he knows how to fix it. So it's not like this is somebody who's never been to a court before. He knew all he had to do was file it the right way. Plaintiff tried to retreat in his brief to Federal Rule of Civil Procedure 83A2, where we shouldn't apply these rules such that a plaintiff would lose any right because of a non-willful failure to comply with the rules. Here, plaintiff hasn't lost any right. And there's not a non-willful failure to comply. This is a willful failure to comply. It's a refusal to comply. He knew he couldn't file by fax, and he knew how to file by paper. He intentionally has done the exact wrong thing, and he has done nothing to fix it except to come here. And this is the inappropriate venue to do that. The circuit court was right, the district court was right to apply the rule. Plaintiff has had a full year to fix it. He intentionally chose not to. It's a strategic decision on his part. The district judge doesn't have to coach the plaintiff on how to proceed the best manner with his case.
No, but we have said you need to give pro se litigants the benefit of the doubt and can't expect them to know and do things that lawyers might do, right?
Right.
And we can cite a lot of cases for that proposition.
Yes, that is true. But this is simply a service issue. All you had to do is refile.
But the district court, let's posit that if the district court, so one possibility is the district court gives him order to show cause. The other possibility is that in the dismissal order, the district court says all the stuff you've just said. I mean, I think this case becomes very easy then. But the district court didn't just say any of that. It was like, case dismissed. That's all it said. It didn't say, here's the problem, but you're telling me there's lots of ways he could fix it, except the district court doesn't identify any of the ways he could fix it.
Yeah, and it really, the question comes down to is it really the district court's job to teach somebody to do that? And we would obviously say, of course, no, with a lawyer.
Absolutely,
If the person's represented by a lawyer, we don't need to do any couching, we don't need to do any coaching, we don't need to help them. So I think that's clear there. Plaintiff has had a lawyer for a period of time at this point. And I think part of that time falls within the saving statute. So he has counseled. So that is a factor that comes in. This is not just a one-off pro se litigant. This is somebody who's had an attorney for quite a while now. Still no effort to refile.
Counsel, you've got a fair amount of time left, but I'm wondering what else there is you would have to say that you haven't already said.
Unless you want to talk about Brit and applying Brit to this case, because that's mildly interesting, but I don't know if there's anything new to cover on that. So unless there's any other questions.
All right. Thank you very much, Mr. Buck.
Thank you.
Mr. Cooper, you've got some rebuttal time.
So again, I would just reiterate the fact that the appellant here did present a complaint to the district court that was filed, it was delivered, and I believe that, you're talking about the court could have given a show cause order, but I believe it was improper to terminate his litigation, given that he did, in accordance with the requirement to deliver a complaint to the court, actually initiate the prosecution. He should have been allowed to proceed on that after having been required to, bring his filing in conformity with the local rules if the district court felt that he had violated that. So I would suggest that it was erroneous to dismiss the case outright rather than giving the opportunity to cure in this manner, and would ask that the court so hold that if a civil action is commenced by filing the complaint is indeed filed by delivery to the clerk, that it is permissible at that point it's required for the court to then proceed on that after giving the litigant the opportunity to come into conformity with any procedural or defects of form. So that is the position that we take in this regard.
All right. Thank you very much, Mr. Cooper. The court appreciates the argument of both counsel, and we'll come down now to Greek counsel and then move on to our next case. Mr. Bielert, did I get that right?
Yes, Your Honor.
All right, we'll be glad to hear from you.
Good morning, may it please the court. My name is Jeff Bielert. I'm here on behalf of Empower Oversight. This is a FOIA case. Empower filed 3 separate FOIA requests. In response to each one of those requests, it is undisputed in this case that the National Institutes of Health failed to abide by the statutory deadline either to issue a determination or to explain to Empower Oversight why unusual circumstances warranted extra time for the NIH to respond. In fact, the NIH essentially sat on its hands and did nothing until Empower Oversight filed this lawsuit. Even then, the suit was filed in November. The NIH still did not issue a determination as to these 3 FOIA requests. It took a month for one of the requests, and then for the others, they were issued, the 2 others, in February. Empower Oversight in this case argued below it had 3 different claims. The first claim was this violation of the statutory deadlines, which again is undisputed as a matter of fact that the agency did not issue the determination within the requisite time that it was required to do so. And Empower brought that as a separate claim. Empower sought declaratory relief on that claim and argued that below. And the reason why Empower brought that claim in the district court was because there are cases that recognize that a plaintiff in unique circumstances may get declaratory relief from a district court even on a FOIA claim. And so
you're basically arguing, I take it, that there's a standalone cause of action for late response.
So there's 2 distinct deadlines, and I just want to be clear about this. The response that we're talking about is sort of this statutory obligation to have a determination made as to each one of the requests. That is the standalone claim that we're bringing.
This is the 20 days?
20 days or the 10
Right.
working days that they can get additional time. But they have to respond, right? The agency has an obligation to let the requester know what's going on.
But so you are arguing, in response to Judge Agee's question, you are arguing that there is a standalone claim for missing a statutory deadline?
Yes.
Okay. And what's your best authority for that?
So, Your Honor, we cited in our brief, there's a series of cases in both the DC Circuit and the Ninth Circuit as well. Counsel for the government acknowledges these cases. They're characterized as sort of a pattern or practice claim.
Right.
In this case.
Well, you have an alleged pattern.
That's correct, Your Honor. But there's no legal distinction between, and this is a case that we did cite coming out of California, where the district court basically said that there's sort of 2 sorts of claims that you might be able to establish that would require the court to consider whether declaratory relief is appropriate. And one of those is when you're alleging sort of this pattern or practice. You're using the magic language, pattern or practice.
But you didn't allege that.
No, that's not in our complaint. We don't dispute that. What we alleged is
And
there's
the reason is that the theory of that kind of complaint, I think there's a DC Circuit opinion I read that says this, like, I keep submitting FOIA requests. They keep missing deadlines. I intend to submit FOIA requests in the future. I have no reason to believe they won't. Based on the fact they've missed it every time in the past, I have every reason to believe they're going to miss it in the future. Please order them to not miss it in the future. That's the sort of essence of a pattern or practice claim.
Yeah, so you could have an injunction or you could have a declaratory judgment. And then
this is the DC Circuit case about like the presidential family's travel. They're like, every single time I submit to the Secret Service a FOIA request, they miss this deadline.
Correct.
I'm going to keep submitting them. Please order them to not miss them again.
Right. So there were, I think, 5 requests in that case. That was the Judicial Watch that was the case you're describing. What I'm talking about is there's a district court case out of California, we cited in our briefs. There's also a set where there's a set of requests. Here we submitted 3. There's no question that the NIH did not comply with the statute in response to any one of the 3
What about,
requests.
we have a prior decision, which is Regulated Management Corporation versus Legal Services, that says it is undisputed that a challenge to a particular denial of a FOIA request becomes moot if an agency produces the requested documents. And they produced a lot of documents.
That's correct, Your Honor. So this is important, and this is a distinction that I think was missed on the district court. When you're talking about a promptness claim. So this is a separate statutory deadline. Cases that are addressing promptness claims, again, this is a different part of the statute. We're not talking about the 20 and 10-day deadlines. We're talking about the promptness of an agency's production of documents. That's a claim that is often raised in FOIA litigation, and it is true, and I do not dispute that the DC Circuit, this court, other courts have held that in that case, the promptness claim becomes moot. Here, and this is what Judge Heitens, I think, is getting at, and I was trying to explain, is in that district court, what you have here is a set of 3 requests. You have a party who is, in fact, engaging in FOIA litigation. I added a footnote. This is an organization that is dedicated to ensuring that there is government oversight and that they are committed to the purposes of FOIA. That's why they do this. They are submitting FOIA requests. They submitted 3 of them. There's no question that the agency did not comply with the statutory deadline requirements in responding to those set of 3 requests. It is likely to occur in the future because Empower Oversight continues to submit requests.
But you don't allege that.
I'm sorry?
You don't allege that. Where does it allege that you intend to make FOIA requests in the future?
There's a reference to, I think it was the mission of the agency, the fact that we were seeking to, it was a point made in the district court. I don't know if it was made in the briefing or it was made at a hearing, but this was
That seems pretty important, whether you allege that you intend to do this in the future or not. Like, in terms of your ability, I mean, like, I know this isn't like a Los Angeles versus Lions standing type thing, but it's like adjacent to it. Like, do you intend to do this in the future? Seems like a pretty important thing to allege or not allege.
Yeah, I agree, Your Honor. I think this argument was made. It was made in the district court. I don't.
Right, but I think the point is that you have to, you just can't put the opposing party, whether it's the government or somebody else, on notice of a claim that's not in your complaint.
Well, it is in the complaint, Your Honor, and we clearly asked for declaratory relief. We clearly brought this as a standalone claim. We cited to the statute itself.
Where is it in your complaint that you intend to keep filing these FOIA requests? I thought that was what you were talking about.
Oh, sorry, I don't know if it came up, there was 3 hearings, there was.
Right, but the hearing is not the complaint. The complaint, where does it allege that in the complaint?
Yeah, I don't have the complaint in front of me, Your Honor. I don't know if there's a specific instance where there's a line in there. I think it was describing what Empower Oversight does and that it is engaged in FOIA litigation, and that it.
Well, even if it's engaged in FOIA litigation, it may not necessarily be engaged in FOIA litigation with the NIH. I mean, it could be some other agency, and I'm not sure how you could make a quasi-practice claim against NIH for something that you're going to do with the FBI or the DEA or somebody.
Correct, Your Honor. And I think, to be quite frank, I think that the agency itself, or the organization itself, as a nonprofit, frankly, given what it had to go through in this case with NIH, has not filed something against NIH. And I'm sure that it will. It continues to file FOIA requests. I don't know how often it does. I'd have to go look it up. But not all of them go to litigation. This is, obviously some get resolved before that. This is an example where an agency did nothing for several months. It's a set of requests. It's a set of requests that were treated essentially the same. In other words, there was no action taken. So Empower Oversight brought this claim. It's supported by the case law. It's supported by the case that Your Honor mentioned, the Judicial Watch case. There's cases in the Ninth Circuit that recognize this. This court should follow those cases.
Well, we have a case, Coleman versus the DEA, that seems to say that the remedy for failure to timely respond is that the agency is barred from posing an exhaustion defense, and that's your remedy.
And that says
nothing. Maybe right or
nothing.
wrong, but that seems to be what that case says.
We acknowledge that in our briefing. The DDC does the same thing. There's plenty of cases that say that. That says nothing about what happens once you get into court. All that says is
No, it really does. It says the defendant had a defense that they might otherwise have had that they now don't have. That happens in court. It gives them it takes away a defense they would otherwise enjoy in litigation.
It does not take away a district court's power under well-established case law to issue an injunction. This is the renegotiation board case out of the United States Supreme Court that tells you that the exclusive remedy is not just an injunction telling the agency that it has to produce documents. I mean, the court has discretion and can exercise that discretion to issue an injunction or a declaration consistent with the goals of the statute. And the goals of the statute are clear. Congress made FOIA to open up agency decision-making and to allow a requester to come into court and to seek that information.
I have a question about the merits of the sort of underlying request,
Sure.
unless you have something you want to finish on this.
No, Your Honor.
Can I ask you about the NIH employees' contact information?
Sure.
How does that help the public understand the relevant sequence of events about why this data was removed, giving people's email addresses?
Yeah, I'm not so sure that it's about the contact information, Your Honor. As to the redactions, Exemption 6 is at its zenith in terms of openness when it comes to personal information, and the statute uses the term similar files to medical and personnel files, so it has to be a similar file. What we're really concerned about is the names, and this is something the NIH acknowledges. There was one name of a requester that asked the NIH to withdraw information that was posted online. One of the Chinese researchers named China at the time of the Wuhan market, or whether it was a lab, whatever is going on, right? The senators.
Are these the researchers' names, or are these the names
researchers' names.
of NIH employees?
So there's the NIH argues that the same privacy concerns apply to the researchers. But foreign citizens of China essentially have the same privacy interests as the NIH employees. The curator, I think, is another example where we did fight and we did get that name redacted. To the extent that there are other names, the privacy interest in your name alone, I think it does go to what was going on inside the NIH, who knew, and who were they talking to. There's plenty of documents where they didn't redact the names. There's others where they did. So that's the argument on that. As to the searches, Your Honor, I just want to, there needs to be sufficient detail in the affidavits explaining what was going on. We are challenging the searches that the NIH did because the declarations submitted by Mr. Garcia Molin don't provide the level of detail to explain why one search, which essentially has the same exact parameters, he just outlines the same thing, that was conducted once and then conducted twice. As to the Congress request, that search, again, it lays out the parameters, yielded 17 pages that were produced to empower oversight. If you look at JA 275, paragraph 45, he lays it out. Then it says in the next paragraph, and then 777 pages were produced. But like, why? What changed? The parameters are the same. He searched the same executive office within the NIH. He applied the same search terms in response to this, and yet the second search yielded 777 pages. How can we possibly understand or challenge that search when we don't know, there's not enough sufficient detail in this record?
You got the 777 pages?
That's correct, Your Honor, yes.
Well, you got what you asked for, didn't you?
I have no idea what else is out there, Your Honor. The fruits of the search are not what makes the search adequate. It's the methodology. And there's a requirement that the affidavits that the government submits must be sufficiently detailed. Here, it's not there. You have conclusory statements issued by the FOIA officer essentially saying, here's what I did, here's what it yielded. That's not adequate, Your Honor. I'm sorry, but it is not adequate to cite to, it doesn't matter if it's 2,000 pages, 3,000 pages, it's not the adequacy search is determined. It's by the way in which the agency went about this. And here on this record, we did argue below, and I'm arguing here that it was not sufficiently detailed. The congressional FOIA request is a very good example of this. I've given you the citation. The government says that all that could have been done would be that it would be required to run the same searches. That's incorrect. What the government misses here is the opportunity for Empower Oversight to make these arguments to the district court. And if all you have is a conclusory statement issued by a FOIA officer, you're depriving Empower Oversight or any other FOIA requester of the ability to challenge that search. I have 5 minutes for rebuttal, so I'll wait for that unless the court has
All
any other
right,
questions.
thank you very much. Ms. Loftus.
Good morning, Your Honors, and may it please the Court. Megan Loftus, Assistant United States Attorney here on behalf of Defendant Appellee's National Institutes of Health, or NIH. Your Honors, NIH respectfully requests that you affirm the entry of judgment in its favor on all three counts. I'll turn first to count one, which is the timeliness claim. This statute, I believe, as Your Honors alluded to a few moments ago, the statute already provides a solution for a requester if the agency misses that 20-day deadline. That's found in 552C1. If the agency fails to comply with that deadline, then the remedy is that there is no defense of administrative exhaustion that the agency may raise in federal court.
Ms. Loftus, can I ask you about something you seem to work very hard to avoid saying directly in your brief? The NIH violated this rule, right? You don't actually come out and say it in your brief. You're like, they didn't meet they violated this rule, right?
Correct. They did not meet the 20-day deadline.
And it's not optional. This is not a NIH can, it sounds, and let's posit I'm sympathetic that oh my God, this is really hard, and oh my God, these deadlines are really short, and oh my God, it's NIH at the pandemic, and so they might have excellent reasons, but under the statute, none of those things matter, right? The I've got other things to do is not an excuse to violate a statutory command.
That's correct.
Okay. So we have to decide this under the assumption that they violated the statute.
That's correct.
Okay.
And as the statute also says, if the agency misses that 20-day deadline, again, the administrative exhaustion defense may not be raised. As Judge Agee pointed out, that's the Coleman case from this court. That's similar to what the D.C. Circuit found in the Crew v. FEC case from 2013. Basically, in terms of the penalty, I use in quotes, is that the agency cannot rely on the administrative exhaustion requirement to keep cases from getting into court. But even if the district court could enter a declaratory judgment on the timeliness issue, which again we posit is not proper under the statute, that request is moot here. That's the cornucopia case from the Seventh Circuit, which faced the exact same situation where the agency, I believe it was the Department of Agriculture, missed the 20-day deadline. At the time of adjudicating summary judgment, the agency or the requester was not asking for any additional documents, was not challenging any redactions. The Seventh Circuit found that issuing a declaratory judgment in that circumstance would not impact the requester in any way because the merits of the action were moot. The FOIA statute is designed to either enjoin an agency from improperly withholding documents or to compel the agency to produce documents that it hasn't already produced. Once that's done, there's no further relief on the merits that the court can award. At the time here that count one was adjudicated, Empower's case on the merits was moot because Empower had received, as the district court held, the search was adequate, the redactions with some exceptions not at issue here were proper. The cornucopia case does say that it might be relevant, the declaratory judgment for fees. However, on that record, declined to award on the timeliness issue because, again, the court found that the requester had not substantially prevailed. Additionally, as your honors noted, there's no allegation of a pattern or practice claim here, and I would point the court to JA 19, which is count one, which lists the relief that Empower is seeking, under count one, and then JA 22 to 23, which is a specific alphabetized list of the relief sought. There's nowhere in there that there's an allegation that Empower will again seek to make a FOIA request of NIH.
What about taking all the allegations of the complaint together, that the agency repeatedly failed to meet the deadlines, like one after the other, and failed by a pretty wide margin to meet them? Why could that not be viewed as a pattern and practice, even if the magic words are not in the complaint?
Sure. So in this case, there were 3 requests at issue. In the pattern or practice cases, which are described in our briefs, I think the Secret Service case, which I apologize that I believe it's a Judicial Watch case, but there are a lot of Judicial Watch and a lot of Crew cases, so it's sometimes hard to distinguish. But in that case, there were, I believe, over 6 lawsuits. There were 29 different FOIA requests where the agency had missed, and there was a pattern of the Secret Service for pretty benign requests of just looking for receipts and reimbursements, of the Secret Service not responding, not doing anything until a lawsuit was filed. The lawsuit was filed and documents were then produced. And so I think for a pattern or practice claim to lay, even if it were properly alleged in this complaint, there would need to be a far more, frankly, egregious list of requests that were ignored. I know my opposing counsel mentioned that NIH did nothing until this lawsuit was filed. Frankly, I don't think that's supported in the record because, as we highlighted in our briefs, Empower never filed a motion for attorney's fees. And so we did not have a record of what the agency was doing prior to the complaint being filed, because, as this court is aware, simply filing the complaint and then documents coming thereafter is not enough under the statute to demonstrate that a requester substantially prevailed.
Mr. Bielert also argues that the agency's explanation of their searches or what they were doing to look for the documents was inadequate. What's your response to that?
Your Honor, I disagree with that, as you might have guessed. The standard is looking at the four corners of the request and figuring out where in the agency is most likely to have responsive records. I believe Mr. Bielert spoke specifically about the congressional requests. I'd like to note that in between the first and second request, so the first search on that request, NIH searched the Executive Secretariat, which is a small office within the Office of the Director at NIH that every congressional correspondence is funneled to. On the second search, and in fact this is a J274, paragraph 44, NIH actually went and expanded its search to a second office, the Office of Legislative Policy and Analysis. That then resulted in the additional 777 records, I believe, or pages that were discussed. So it is not the case that NIH did not explain where it was looking or why it was looking. In fact, there were some intermediate proceedings before the district court. The district court had made some suggestions, if you will, as to ways that NIH could improve its search, and the agency took that to heart and went and did that. Additionally, Empower had identified, I believe, 4 custodians that the agency, that it would like the agency to search. The agency did that. There's no, outside of those 4 custodians, there's no record, and Empower doesn't posit that it asked the agency for anything additional. And
The actual unredacted response letter to the senators was produced.
the redacted, so
I thought it was unredacted.
Oh, I'm sorry, yes, the actual response letter, yes, that was produced. I mistook Your Honor for asking about the draft responses, which are at J431. In preparing the responses to that draft, one of the NIH employees embedded the draft responses right in the letter so that somebody reviewing what NIH was going to say could look at the request and look at the draft response. I know Empower takes issue with the redactions there, claiming that it's purely factual information. It should not have been redacted under B5. Simply because the draft answer may be a combination of facts doesn't remove it from the deliberative process privilege. The Supreme Court's decision in U.S. Fish and Wildlife and the Dudman case from D.C. Circuit read together instruct that the particular combination of facts in a draft is a product of editorial judgment. And the real chilling effect, which is what Dudman talks about, is not in the disclosure of the facts themselves, but that the agency as an institution made changes in a draft at some point. So we also have NIH put together a lengthy Vaughn Index, which detailed every explanation for every single redaction in the 300 pages, or excuse me, 300 redactions that were done. Empower never mentions that index either before this court or below, but the thrust of that document is that it was a draft that was being prepared. It looks like it's almost a final decision, but it was just for ease of reference for the reviewers. If I did want to go back, Your Honors, just briefly to the timeliness claim. Mr. Bielert mentioned the Our Children's Earth Foundation case, which is a district court case from the Northern District of California. That case had 2 agency defendants. One was from the Department of Interior, the Fish and Wildlife Service. The other was from the Department of Commerce, the Fisheries Service. The district court considered whether it should enter a declaratory judgment on violating the 20-day statutory deadline, and it actually came out separately as to the 2 defendants. And I think what was motivating the decision there, if you have a chance to look, is that the Fisheries Service had a pattern or practice with respect to the particular requester of not answering FOIA requests in a timely manner. There were many requests. There was a significant delay in receiving documents, many more months than at issue here. And so the district court first said, as a matter of statutory interpretation, it's correct that the FOIA statute itself, the remedy for the 20-day violation is a waiver of the administrative exhaustion defense. But sitting in equity, the district court found that it could offer additional relief in the form of this declaratory judgment because that would provide some guidance going forward to the fisheries service and clarify the relationship between the two parties who are likely to be engaged in FOIA disputes again. The district court did not issue a declaratory judgment as to the Fish and Wildlife Service because even though they had also missed that 20-day deadline, it was because the fisheries service had referred out documents for Fish and Wildlife to say, yes, you can release or no, you can't, that even though they had missed that deadline, there wasn't this pattern or practice of delayed responses with Fish and Wildlife Service, and there was no allegation that the particular requester at issue was going to again be requesting from Fish and Wildlife Service. I'd also note in the briefs, Empower relies on a judicial watch case from the DC Circuit in 2018, a concurrence, but that case, for the proposition that this 20-day deadline has some kind of separate enforcement mechanism that what's already in the statute, the concurrence actually did not reach the question of whether the 20-day deadline had a standalone violation provision. And just briefly, again, on the timeliness issue, the renegotiation board case that Mr. Bielert cited, the question presented there was whether the district court had jurisdiction under the FOIA to enjoin the renegotiation board process until the FOIA claim was resolved. And it actually didn't decide that particular issue. It held on the exhaustion grounds. So NIH does not believe that that case stands for as broad a proposition as Mr. Bielert suggests it does. Finally, as to the B6 redactions, the personal privacy redactions, I would note that the cases that we cite in our brief describe the public interest and what's required and what, especially in light of a privacy interest here by both a lower level NIH employee and the Chinese researcher, that even though there is a public interest in learning about how the pandemic originated and what the government knows about that, what the government's doing, I don't believe that Empower has articulated how learning the names of first the NIH employee would add to that, and second, the name of the Chinese researcher would add to that. I think the logic of the Pinzon case, where it was discussing foreign governments, I believe it was a 7C case, but the logic is similar in that the requester wanted to know the identities of foreign criminal investigators who were assisting the FBI. And the district court held that it's not so much that individuals themselves, it's that a foreign government is assisting in criminal investigations in the United States.
Well, I don't know if it was articulated when it was articulated first, but today your colleague said one of the reasons we'd like to know the name of the Chinese researchers, I'd like to know if that individual is also publishing papers that say things about the origins of the pandemic, like super duper definitely not this thing, right? Like that. So that's something you articulated today about why they would want to know the name of that person.
Right, Your Honor, and I'd highlight it was something articulated today, so not something we've had the opportunity to discuss both before the district court and brief before this court. But I think...
But like, at least in principle, that seems plausible, right? Like, I'd like to know if the person who submitted this data and then asked to take this data back was then publishing articles about this exact same topic that might shed light on why they would submit and then withdraw data.
Sure, and that is understandable. I'd also note, though, the Lauer Declaration that we have in the record, and there was reference below to public news reports about researchers in China, in particular, for their speaking out about COVID and penalties that they might face by their government for doing so, particularly around this question of how the pandemic started. So I would say, again, I'm completely speculating, so for what that's worth, I would say it's probably unlikely that the researcher is out there publishing that kind of material, but even if he or she was, I think the NIH is rightly concerned about the type of threats that individuals kind of associated with this question are facing, that it's a very real threat for the agency that they're very concerned about.
If the Empower had made their specific argument that they made today in their complaint in the district court, would your response be different?
No, I don't believe so. I think we still would have asserted that there is a substantial privacy interest here, that the public interest in learning about the origins of the pandemic is already satisfied when Empower holds the information that it's a Chinese researcher affiliated with Wuhan University. And really the question of the public interest under Exemption 6, as this court held in Solers, is the government, for an individual to understand what their government is up to. And so yes, while the question of what a researcher may or may not be publishing, that could be an important question to decide. The inquiry under Exemption 6 is how is this going to help further what the public knows about what its government is doing? Is it fulfilling its statutory duty? And we would likely have argued that that purpose doesn't fulfill what Exemption 6 is how Exemption 6 defines the public interest. Unless your honors have any further questions, NIH respectfully requests that you affirm the entry of judgment in its favor.
All right, thank you, Ms. Loftus. Mr. Beeler, you've got some time remaining.
Thank you, Your Honor. I want to start sort of where we just picked off or ended with this notion that we did not address the Chinese researchers' names. This was addressed at the hearing. This was addressed in the fight over sealing the names. Empower Oversight has always maintained that those names should not be redacted. There's a footnote in our, I think, opening brief where we cite to another case.
Are you putting the NIH employees and the Chinese researcher in the same basket?
I'm not necessarily. I think the case for the Chinese researcher is even stronger. These are, in fact, public people that are teaching at Wuhan University or writing papers. The one researcher name who was unredacted, in fact, has published papers addressing COVID-19, and his research ties directly to the information that Empower Oversight seeks. We cited specifically the concerns raised by the senators in this exact context, that the government, that the people have a right to know what their government is up to and what their government knew. FOIA establishes a very strong preference for openness. Here you have in the NIH's brief citing to misinformation. This is an agency deciding what information goes out to the public. Well, if you want to fight misinformation, you follow FOIA and allow the information to get out so that people aren't looking behind black boxes coming up with conspiracy theories. That's not what's going on here. This name of the Chinese researcher should have been redacted. It was done in other FOIA litigation. It should have been done here. As to the Vaughn Index,
You mean it should have been unredacted?
it should have been unredacted. It should not have been put behind a B6 black box. As to B5, the government misunderstands the duty to segregate factual information. This is, again, an argument that Empower Oversight made throughout this litigation. There is an obligation to segregate. You must go through and have factual information not be put behind a massive B5 box. We cited in the record plenty of B5 boxes. It strains credulity to suggest that the answer to a senator's question specifically asking for facts, that there's not a fact that can be not redacted, right? I mean, we made this argument below. We stand by it here. As to the declaratory judgment, the cornucopia case, you heard the government counsel, she already acknowledged that they did not seek to challenge the scope of the search, and they did not seek to challenge exemptions in the case. Very different from this case. Pointed this out in our brief as well. There was a judicial role to still be performed, and it was in fact performed. There were 3 hearings. There were several orders. The court went through and looked at the searches and looked at and actually forced the government to unredact some of the things that it redacted. So it's certainly not true that this case is anything like cornucopia. Each case turns on its unique circumstances. Our point is that lower courts, district courts, have the authority to issue injunctions and to issue declaratory judgments. FOIA didn't change that. The court can exercise its discretion to determine when that's appropriate. This is one of those cases. Whether I use the magic language, pattern or practice or not, the same effect, it's exactly the same thing that's going on. You have a set of requests, you have an agency that admittedly did not follow the mandatory language, shall, that Congress put into the statute. The agency may not like that, fine, go to Congress, get them to change it. You don't like the deadline, great, go tell Congress to change it. That's not the way that it works. It's a set of requests. The agency admits that it didn't follow the deadline requirements, and there has to be some sort of guidance given to the NIH going forward. That's what a declaratory judgment does. And this record is exactly one of those cases. The government came in its opening brief for summary judgment, and I encourage you to read this. They didn't even address Claim 1. They dropped a footnote. And the footnote says statutory deadlines are irrelevant. Well, they're not.
So say that the footnote says what?
That statutory deadlines are irrelevant is the term that the government uses. Open the opening brief on summary judgment that was filed below by the NIH. They say don't even address Claim 1, focus only on the search, focus only on the exemptions, don't even address the timeliness requirement because it's irrelevant. That's not true. It's not even true on the cases they cite, which is something that we distinguished here and we distinguished below. So I do think this is one of those extraordinary cases where the district court could have and in fact should have issued a declaratory judgment. Frankly, this court's guidance is necessary. Lower courts, they're looking to the DDC. There's plenty of cases in DDC where they get things wrong. Lower courts need guidance from this court explaining the powers that they have and when they are allowed to exercise those. I ask that you reverse the judgment for one of the 3 reasons that we gave in our briefing. Thank you.
All right, thank you very much. The court appreciates the arguments made by counsel today, and I'm going to ask the clerk if she'll adjourn court until tomorrow, and then we'll come down and greet counsel.
This honorable court stands adjourned until tomorrow morning. God save the United States.